So welcome everyone to today's online GAPLA online talk. Now, for those who don't know GAPLA, we are a non-for-profit association which has as members lawyers in different countries, including Germany, Austria, Australia, New Zealand. And what we do is we offer a platform for our members to discuss legal issues around the globe and compare the legal systems, but also exchange experiences and ideas. I am one of the board members at GAPLA, and you should be able to see my fellow board members on the screen, Juliane Werther and Michael Kobras. I am very excited for today's discussion. Today, we will be talking about the role of solicitors and barristers in Australia and the system of advocacy in Germany. Now, the role of solicitors and barristers in Australia is something that I have to explain to my clients every time I suggest that we engage a barrister. They often ask me why that's necessary, and they already have me as a lawyer, and why do we need another lawyer? So I think those are questions that many German lawyers and clients have. So I'm very keen to have a discussion around that. On the screen, you should see our speakers of today. So in one room, we've got Harley Milano, who is a solicitor at Resolve Litigation Lawyers, specializing in commercial litigation. He's based in Sydney, and sitting next to him, also based in Sydney, is Dr. Simon Blount, who is a barrister at State Chambers in Sydney. And Simon practices in administrative law with a focus on judicial review and immigration, as well as taking on general commercial matters. He appears in all levels of New South Wales courts and also federal courts, including the High Court. Apart from his practice as a barrister, Dr. Simon is also an academic and teaches law at the University of Notre Dame and the University of New South Wales. So you've got your hands full, Simon.
Thank you very much.
Most importantly, Simon, you've got a Viennese background and you're fluent in German, which I didn't know until today.
Look, I wouldn't say fluent. I'm very grateful to be able to present or take part in this discussion in English, because I don't think that my German is quite up to the legalese. But yeah, I can sort of I can find my way around Berlin without too much trouble.
And, good. We might test you on that, Simon, later on. And lastly, with us today is Tatjana Giorgis, who is a lawyer in Germany at, don't let me get the name of your firm wrong, lawyer at Hyazinth Lawyers.
Hyazinth or Hyazinth?
Yes, it's not easy to pronounce. And Tatjana, you specialize in litigation and dispute resolution. So you are basically the counterpart of Harley and Simon in Germany.
That's correct. Yes.
Well, welcome to all of our speakers, and I might now hand over to Harley to kick off the discussion.
Okay, well, everyone, thank you for having us, and Simon and Tatjana, thank you for agreeing to present. I guess the first thing we should address is the fact that when you talk about a lawyer in New South Wales, you're really talking about one of two different professions, and you know, on the left and right, we have a sort of caricature of both. So you have the solicitors, who are engaged mostly in paperwork, and they look like they're having quite a lot of fun over there. And then you have the barristers who dress up in Georgian era wigs and present in court. So Dr. Simon, I just wanted to ask you firstly, is that a fair representation of the split in the profession?
It certainly was 200 years ago. When Tatjana and Claudia and Juliana and myself met briefly yesterday, I found myself saying, look, the split, if you like, in New South Wales between solicitors and barristers actually goes back hundreds of years. And in fact, barristers were the first common lawyers. Barristers appeared in court and tried to persuade the judge to their client's point of view. And then solicitors made an appearance somewhat later and held themselves out, if you like. They solicited for work, they touted for work by offering to draw up documents that clients could then give the barrister for the barrister to use in court. So certainly hundreds of years ago, the division between the solicitor who did the paperwork and the barrister who did the oral presentation certainly was correct. Because our traditions are derived from England, it was also class-based. And until relatively recently, barristers were considered to be gentlemen and gentlewomen, whereas solicitors perhaps not quite so much. So many of the traditions that emanate from England are class-based, and I think the split that we have in the profession in New South Wales is one of those old class-based distinctions, although of course much of what I've just described to you is now gone.
Well, yes, I mean, you've talked about historical roots that stem from the colonial era, but there's obviously compelling practical reasons which have meant that the split has continued in New South Wales.
Yes. I suppose if barristers weren't useful, we would no longer exist. So what is it that barristers can offer that solicitors can't? I think the first and most important thing is that barristers are specialists. Solicitors are really generalists, even if they specialise in a particular area of the law. They tend to be generalists in that area of the law, whereas barristers, of course, are specialist advocates. We are expected to know how the courts work. We are expected to know the judges, and we are expected to be up to date on the latest changes that are happening that we need to be across in order to make an effective representation.
Okay, so I suppose that might free up solicitors to focus on engaging with the clients, and the barristers focus more on keeping abreast of the specifics of courtroom practice and procedure.
Very much so. I think that one of the things that a barrister can offer a client is objectivity. Now, there's no doubt that solicitors obviously remain as objective as they can in respect of their client, but it is actually of assistance, I think, to a solicitor. For a solicitor to be able to go to a barrister and say, look, I've had a long association with my client, and you know, perhaps we just need an outside person to come in and just be completely sort of clear about some things that I'm having difficulty explaining to my client because of our long association. So yes, I think we bring objectivity to the relationship.
Okay, so if I might move to the next slide. I mean, this is material that we've sort of begun to address. It sort of goes to what Claudia was saying, that perhaps initially explaining to a German client, you know, he's used to there being a client and then a lawyer. It's sort of puzzling why we need to hire a second person. And in fact, Dr. Simon, if I'm not wrong, there used to be a rule that barristers could not be engaged by clients. So it's actually, there needs to be the go-between of the solicitor. So I suppose what you were saying is that this sort of system can work because although it might seem inefficient to have, you know, multiple layers of lawyers, in fact, that separation between the barrister and the client allows for some objectivity and an independent analysis of the case. So I think sometimes as solicitors, because we have a very close and even long-standing relationship with our clients, it might be more difficult to tell them no. Well, you know, your case is flawed in this way, or your prospects of success are this. So it's valuable to get an outside perspective from counsel.
I think, Harley, you're absolutely right. And just about every barrister in practice at some point has said no. And that's one of the valuable things that we're able to bring. But I also think it's important to realise that barristers don't just duplicate what solicitors do, that they're quite separate functions. That obviously the solicitor, if you like, will translate, if you like, the client's needs into a form that the barrister can present to a court. And the barrister then advises on, obviously, the proper court, the procedure, and often on the evidence. What types of evidence do we need? For instance, if we need an expert, the barrister should be able to articulate exactly who that expert should be. For instance, there's more than one case that has collapsed because the wrong expert was giving evidence. So, for instance, where a psychologist was engaged, where it should have been a psychiatrist, and problems like that. And barristers are supposed to be, and generally are, on top of that sort of procedure. So we're not duplicating, we are advising what needs to be done in order for the court to properly assess the client's position. Certainly.
Yeah, and Dr. Simon,
before we go on, sorry, Harley, before we go on, I've noticed that we've got one participant who's raised a hand. Katerina, do you have a question? I think, hang on, I think you can't unmute yourself.
I think there are a few people that are muted.
Yes, I think there's actually no question. No question. Okay, I can see Katerina from the neighboring room. So she's just confirmed there's no question and we can continue moving on. Sorry about that.
Okay, good. No, good. I mean, Dr. Simon, you're talking about how involving a barrister can lead to better outcomes.
Yeah.
I also think that there's a sort of way that things can be set up where things can actually be done, these proceedings can be done perhaps more cheaply by engaging a barrister, because you know, if you consider the hourly rates of a first-year solicitor, that might be X dollars, let's say $200 an hour.
Mm.
The hourly rates for a first-year barrister would be around that, wouldn't you agree? But that first-year barrister might have anywhere from 5 to 10 years experience as a solicitor before that. So I suppose, you know, something that I could do in X hours, 5 hours or 50 hours, depending on how efficient I was, a barrister might be able to do that more quickly.
Yeah, I think that if a barrister is properly used, he can actually, or she can actually be a lot cheaper than using a top-of-the-line solicitor. I'll tell you a story first and then I'll give you some practical examples. That junior barristers are often briefed to go to short procedural hearings in front of a junior judge in which the parties inform the court of the progress that they're making leading up to the hearing. Now, a barrister would charge typically maybe $250, maybe $350 plus GST to do that very brief appearance. I have on occasions seen partners of law firms appearing at these short directions hearings, and with them is their associate, and with them is their junior solicitor, probably all of whom have participated in the drawing up of very simple orders, and all of whom will be charging, you know, for their time. Now, they're not doing anything wrong, but for the orders and the brief presentation made by the solicitor that have been drawn up for a total cost of maybe $1,200 to the client, a single quite junior barrister working by themselves is going to achieve exactly the same effect for 1/4 possibly of that price. And the reason why barristers are cheaper is that our overheads are much cheaper. We are all sole practitioners and we don't have the overheads that are associated with solicitors. Solicitors typically in the large firms that I'm aware of work very much in teams. So there is a graduate lawyer or a junior lawyer who does an initial draft. It's then improved by the associate. Okay, it's then read by the partner, and then it might be sent back down the chain for more changes. Now, that is a way of working, okay, that gives a client very full service, and it's a way that checks that no mistakes are made. But barristers just don't work like that. We work on our own, and we're responsible for our own work. So whereas an hourly rate, for instance, of an associate in a larger firm might be $600 an hour, a junior barrister might be half to 2/3 of that, simply because the junior barrister doesn't have the overheads that are associated with a large law firm.
Yeah, well, thanks, Dr. Simon, for that very insightful and indeed frank perspective on the relative economies of solicitors and barristers.
Yeah.
I might just move to our next slide. Tatjana, last time we were discussing that I think the paradigm in Germany has been that if you have your zweite Staatsexamen, then you're basically qualified to do anything that a lawyer can and should do. But having said that, there's sort of a trend towards having specialist litigation and advocate lawyers in Germany. Could you tell us more about that?
Yeah, exactly. That's completely right. So, I mean, you probably all know in Germany, the lawyer profession is more like a one-stop shop. You can get everything. You can get a contract. You can get represented in court. But recently, especially on the business level, and bigger law firms, American law firms have entered Germany in, I would say, the late 90s. It's more and more common to specialize as a litigation lawyer, which is also a new word describing a specialization in Germany. And it means basically you specialize in the civil procedure laws and the court appearances and representation of the client in court. And that makes sense. And it is basically for the same reason that Simon just mentioned. It's practical reasons. Big law firms usually have businesses as clients, and they draw their contracts. They do M&A work, venture capital a lot. And at some point, the client comes up with a dispute. And no one really has experience in going to court because everyone is drawing contracts and is working with paper a lot. So they need someone who's specialized in that field, and it just makes sense to outsource it a little bit in-house and have one lawyer who specializes in those court appearances. And that's my job, basically. And it has the same effect. It also gives a little bit of an objective view on a case, because often my colleagues, they promise a lot to their clients that they worked with for years. And then I come in and I'm spoiling the fun. And I'm like, yeah, but your prospects are, I don't know, 50-50. And it helps sometimes to get them back on the floor and discuss from a different point of view their case. Yep.
Okay, great. Thank you for that. And in addition to sort of that objectivity that you bring, I'd imagine you'd have to also develop your skills in oral advocacy and also leading oral evidence. Is there a big emphasis on that in German courts?
It's not that much as it is in Australia and also the US. Different to the common law system, because we all have the second bar exam basically, and judges and lawyers are not that far apart. I have a colleague, she will become a judge in a few months. She's like almost 10 years younger than I am. And so we're not that far apart. We don't have that hierarchy. So it's more like a discussion in any case. It's very different in criminal law. In criminal law, you have an oral pleading and it can take sometimes hours. But in civil law, it's more like a discussion and you just present your arguments in a obviously well-structured way. But then you fall into a legal discussion with the other lawyer and also with the judge, who can ask questions and who can raise concerns. And so it's more argumentation than really, like presentation. Yes.
Okay, and Dr. Simon, would you characterize your relationship with the bench, with judges, as a hierarchical or equal relationship?
It's most definitely hierarchical. There's no question about that. I think one of the true differences between the common law and the civil law systems is that the common law, we are adversarial. I am not there to agree with my opponent. I am there to fight my client's case and persuade the judge that my client is correct. Of course, I'm describing a situation where all attempts to settle the case have failed and it has finally come to a hearing. But once we're at a hearing, the gloves are off and I am there to very vigorously press my client's case and as vigorously as reasonable try and undermine the case that's against me. In terms of the relationship between what we call the bench and the bar,
the bench being the judge,
the bench being
and the bar being
the judge and the bar being the bar table that we sit at. It's particularly in the higher courts, so our Supreme Court and our Court of Appeal, which are the higher commercial courts. The judges may like you, but more often than not, they don't. They want to test you. The word we use for a process is a trial. And a trial in its true sense is test. You are tested. Will you overcome the obstacles? Will you come through the wall of fire and still prevail? So yes, judges can be quite severe and they will ask tough questions. And if they don't like what you're saying, they'll tell you. And then you have a choice. You can either move on, or if you think it's a very important point that needs to be made, even though the judge doesn't like the point that you're making, it may be that you just have to keep pressing it, because it may be that that the judge is wrong and you might need to take this point on appeal. So it can be quite a stressful experience at times.
At this point, we've got 5 minutes remaining, I can see on the clock. Tatjana, if you had any further comments, I do like to hear them. Otherwise, Claudia, do you think it's appropriate that we open it up to the floor for any questions?
Yes, I think that is a good time, and I can see there's a couple of there's a good mix today of German and Australian participants, and for Australia there's a few barristers there as well. So happy to receive any comments or questions that you may have.
Do we have anything on the chat? Where is that?
Yes. And I think if there's no initial comments, I think I'm happy to share a bit of my experience. And I absolutely agree with what you said earlier, Simon. A barrister, if used well, can be a really, really important resource and often a necessary resource as well. I have many examples where, you know, you work with a client, you go down all the rabbit holes with your client to explore what evidence is available, what evidence can be provided in court if necessary. And once you've done that exercise of exploring those questions with the client, what a solicitor would usually then do is put the evidence that you think is available to the barrister, and the barrister can then tell you with that objective view that you were talking about whether that evidence is sufficient or not, or will be sufficient or not in their view to persuade the court. And given that, Simon, you would be in court much more than I am, so I'm assuming you'd be in court almost every day. Barristers have a much better understanding of what the court would accept, what the court would expect. You obviously have a very different relationship to the judges as well. You are in front of the judges very often, so you know the judges, what their different styles are, I suppose. So that's, in my view, from my experience, a really, really big benefit of engaging a barrister, even for matters where you don't necessarily have to engage a barrister.
Yes, I think you're absolutely right, Claudia. I think that one really, really important thing that a barrister brings to difficult litigation is helping the client and the solicitor make choices between, between different possibilities. There is and sometimes, they can be difficult choices to make, and it's part of the barrister's responsibility to take responsibility for making those choices. That's part of what we're paid for.
Simon, if I can interrupt you, I can see there's a question coming from Stefan Müller.
Yeah.
Stefan's question is directed to Simon, and it's whether you see a shift towards an inquisitorial style of litigation in Australia. But before you answer that question, perhaps Dr. Tatjana, could you enliven us as to what an inquisitorial style of litigation is?
Well, from my perspective, it's the word is not quite accurate anymore. It is a party trial, and parties have to bring their evidence to court. However, the judges are allowed to request more evidence, and they ask questions to witnesses, or they suggest to hear special expert witnesses. So they're a bit more engaged in the case, and they lead the case, and they also need to give you advice in upfront the hearing, in which direction they think it goes or where they see a lack, so that they organize the trial a bit more closely. And it's not through direction hearings; it's all in writing. And I think that the main part is really that they have a little bit of an influence on the evidence that is provided.
Yeah, I think that's something really interesting. Dr. Tatjana was saying that at the outset of a hearing, the judge might express their initial view, whereas Dr. Simon, is that common in Australia?
Look, it is common that judges will let you know what they're thinking, and that's a good thing, because it's giving you procedural fairness. For instance, I might think that a point has already been made and that it's pretty uncontroversial anyway. But if the judge then lets me know actually that he or she is not sure about that point, then it gives me the opportunity to make further submissions about it, or so forth. Getting on to the point about whether hearings will become more inquisitorial in Australia, like most things in the law, the answer is yes and no. I think that in Australia, we are shifting towards tribunals, which sit in the executive arm of government. In Australia, we think of there being three arms of government: the executive, the legislative, and the judicial. And as a barrister, I'm definitely in the judicial arm of the government. But in Australia, we increasingly use tribunals, which sit in the executive to try and make quicker, less expensive, more informal decisions for individuals who are aggrieved. And there's no doubt that those tribunals are intended to be inquisitorial. Often, Tatjana, I think if you walked into one of our tribunals, you would think this is not inquisitorial as well. It actually looks adversarial. And that's because when lawyers appear in these tribunals, that's what we do. We do adversarial presentations, but they are meant to be inquisitorial. But I think at a deeper level than that, I think when it comes to serious matters, important matters, matters that involve very significant amounts of money, I think our system always will be adversarial. It's an adversarial system of advocacy is woven into our system in just about every facet of it, where you've got each side putting their view and telling the judge why you should not accept the other view because the other view is wrong. We've been doing it for so many centuries now that I can't see there being a fundamental change to that. But I certainly think that as we get more and more tribunals, that more and more of our decision-making will be inquisitorial. But they are, I emphasize that the decisions of those tribunals are not the decisions of courts.
Thanks for that, Simon. And I know we've gone over time, but we do have 2 more questions. So if we maybe have time for 2 very quick questions. Oscar, I can see you've raised your hand.
Yeah, hi. Hi, Claudia. Nice to see you again. Also, Michael. Yeah, thank you, Harley and Simon, for the great presentation. I have a question for you two about qualifying as a barrister in New South Wales. So I studied law in Heidelberg, Germany, and UNSW and Oxford. And in England, when I wanted to qualify as a barrister, I needed to do a type called mini pupillage, either in an assessed or in an unassessed form before commencing the actual pupillage. And as I see it in New South Wales, there's no such thing, but rather there is the readership. So my question is, how many years of practice as a solicitor, in which areas would you recommend doing before starting that readership? Because as I see it, mostly the solicitors in big international law firms, they tend to be specialized in only one specific area, like international arbitration, M&A, or whatever.
Yes.
And barristers, they are much more diversified, and that's also why I find it very appealing to me. And so I would like to hear your insights about that.
Okay, well, I mean, how about I set out the normal path, and then Simon, you can talk about the not normal path that you took. So I think the normal path from high school is a 5-year degree. 3 of that is law, and 3 of that is another degree like business or English or whatever, and 3 plus 3 become 5. So after that,
That's to become a solicitor.
No, well, I mean, yes, that's right. And then you become a solicitor. And then from that point, you can become a barrister immediately, or you can maybe practice for anywhere from 5 to 7 years. I think many people would transition to becoming a barrister when they've reached senior associate level. You might go to Oxford or Cambridge and get your BCL if you're very posh. You might do a 1-year associateship with a judge. And then you do your readership year, which is where you find 2 junior barristers with whom to read, who tutor you essentially and feed you work, hopefully. And just before that, you need to do a bar exam, which is nothing like the Staatsexamen in Germany, but it's sort of, it's just 2 exams over a day. It's nothing to stress about.
Yeah, it's so in order to be a barrister in New South Wales, you must have a law degree. You must have completed your practical legal training. And at that point, you can become a solicitor. And if you are a solicitor, you must work under the supervision of a more senior solicitor for 2 years. If you wish to become a barrister, you then have to do bar exams, and that is 3 exams with a pass of 75%. So you've got to get a pretty good mark in those bar exams, and the failure rate is quite high. A lot of people don't get through those exams. If you get through those exams, you then have a period of pupillage, which typically takes about 1 year. And if you are deemed to be able to go on and practice as a barrister, after your year of pupillage, you can then practice on your own account. In terms of, when is it desirable to go to the bar? I mean, that can really vary. I went straight to the bar. I was not a solicitor first, but many people are solicitors before they come to the bar. And it can range from anything that they have 2 years experience as a solicitor to 20 years experience as a solicitor. There's no ideal way. It can be, coming to the bar can be like having a bucket of ice water poured on top of you. It's pretty tough. And it's also, particularly in your first years at the bar, you can't specialise. You do whatever comes in the door and make the best of it.
That's right, Oscar, because actually I think one of the parts of Oscar's question was that a solicitor might be very specialised, like energy law only or M&A law only.
Yeah.
But can you explain the cab rank rule at the bar?
Yeah, the cab rank rule is quite important to us. It means that as long as we are paid our fee, and as long as we are competent to do the work, we should not refuse a brief. Okay, so in my example, for instance, even if I was offered my brief fee, if I was offered a brief for an indictable criminal offence where I had to run a jury trial, I would be justified in refusing that because it's not within my area of competence. I'm a civil barrister. But as long as it's within my area of competence, I'm obliged to take the matter on. So even if come to the bar and you're a very experienced solicitor, the chances are is that the first, couple of dozen briefs that you're going to get, you're not going to know anything about. And you're going to have to read incredibly quickly and get across them very fast in order to do a good job. And that's part of what it takes to be a barrister.
Thank you, Simon. Now, Oscar, did that answer your question? I think it did.
Yeah, thank you. So maybe one more question. So there's nothing like in England, for instance, something called the commercial bar, where there are chambers that where all barristers only focus on all commercial law related matters.
No, it's not it is not formalised in that way that you seem to be suggesting it is in England. There are no doubt that some chambers are better known for doing, for instance, commercial law or wills and probate or industrial law. But in all of those chambers, there will be barristers who do a wide variety of work. So it could be that in Australia, we're a little bit broader, perhaps, than England, although I'm not sure about that.
Okay, thank you very much, Simon and Harley.
Oh, you're welcome, Oscar. And if you come to the bar, it's a great thing to do. I recommend it.
I'll let you know. Thank you very much.
And we've got, I know we're well over time now, but if we have time for one final question from Alexander, perhaps Alexander, you can keep your question as short as possible.
Yes, good morning, good evening, and thank you for the presentation. Basically, the question's around the sort of distinction between, or the sort of the weighting that we give in both countries to oral and written submissions. I say that because I went to a hearing of a Verwaltungsgericht here, so an administrative court, where somebody was trying to turn a flat into a sort of an Airbnb thing. And my current job, basically the planning department or Bauaufsicht, had turned around and said no. They then taken us to court to try and say, yes, we should be allowed to do it. And what struck me was that the level of written submission was quite high. Then we sort of stood in a courtyard with the judge and the lawyer from the other side, and we talked for about 5 minutes, and then that was kind of it, and the lawyer made the decision on the spot. And my sense of Australian law is that, yes, barristers will probably write relatively long, maybe sometimes bigger written submissions, but then there'll be a lot more oral submission as well. So just welcome comment from both, so from all the presenters quickly, on to what extent you feel like you've got written submissions and how important are they in court cases, and to what extent you've got oral submissions and how important they are.
Tatjana, what do you think?
Yeah, well, as I mentioned that yesterday, right? Our procedures are much more upstream. It's all before the hearing. You have to submit all your written submissions and the statement of claim, the statement of defense, and you usually have some other pleadings in writing. And that's why the judge can basically decide just after the oral hearing and give you his decision. Not always. If it becomes apparent in the court here, in the oral hearing, that the court needs more evidence, or that we need a witness to hear, then you might have a second oral hearing. But it is quite common that you only have one hearing, and it's quite short, depending on the complexity of the case, of course. Sometimes it's half an hour, sometimes it's 2 hours, but rarely it's more than that, except in the higher courts. The Bundesgerichtshof for sure has much longer hearings, but yeah, it's much more upstream.
The experience in Australia is that traditionally the emphasis was on oral submissions. And this is because of our long history going back many centuries in England. About 40 years ago, the higher courts, so our High Court, which is the highest court in Australia, and the Supreme Courts and the Courts of Appeal, started asking more for written submissions. So a written outline of what your argument was going to be at the beginning of the trial is very usual in our higher courts. And then a written summary of our case. So by the time all the evidence has been cross-examined, by the time all the oral submissions have been made, the court then almost always now asks for a written summary. However, in the actual running of the trial itself, it is still primarily oral. No question about that. And an interesting point is that the lower down you go in our court structure, so you go from the higher courts to the lower courts, the less written work you do. And in fact, for instance, a magistrate might, not be very happy with written submissions that were more than half a page, simply because he or she doesn't have time to read them. In our lower courts, they say, look, because you're the barrister, it's your job to tell me what I need to do, what I need to know succinctly so that I can make the decision. So I think that does seem to be quite a significant difference possibly between myself and Tatjana when we appear in courts.
Yes, yes. The judges also sometimes do their own research and case law, and then we discuss specific case law in the hearing and see whether it can apply in this case or not. And it's all very much a legal discussion between lawyers, I would say.
Yeah.
So yeah.
Yeah, that's actually very interesting. It's, I mean, obviously our judges do occasionally look at case law, or more accurately, their associates dig up some case law, but it's not really because the judge is really trying to inform his or herself of the relevant case law that should apply, because that's the job of the barristers to do that. More often, it's where a judge has special knowledge or special experience in a field, and he knows of a case that has not been referred to by the barristers. And then he or she, with a big smile on their face, will hand it down, give you 5 minutes to read it, and then tell them what it's all about, which of course you can't do. But yes, it seems that that aspect, the emphasis on oral submissions in our system, and also the obligation on the barristers to really do the heavy legal lifting, does seem to be quite different from what appears to happen in Germany.
Okay, well, thank you very much to all of you, Simon, Tatjana, and Harley. I think this was a wonderful discussion. I hope it made clearer to our colleagues in Germany why we work in teams in Australia rather than having the one-stop shop that Tatjana can provide for you in Germany. So, thank you all very much.